Hi, my name is P.R. Krishnan. Welcome back to my presentation episode number 9 on inheritance law. In my previous presentation, I covered succession certificate and prior to that, legal heir certificate. In this video, we'll elaborately cover nomination under various categories including cooperative housing society, banks, DMAT and insurance, etc. So, this is a topic that we shall be covering. Let's go to the first topic, that is cooperative housing society. We think nomination, when you think of nomination, the first thing that comes into our mind is either a bank or a cooperative housing society. There are many instruments where nomination is mandatory, like all sorts of investments, be it FD or pension or DMAT, etc. But importantly, it should be there in cooperative housing society where generally people ignore, or the committee members don't ask it, or even the members don't give it. But that is the most costly one because the cost of the flat is very high and you should provide for a nomination there. As long as there is a joint holder, nothing to worry. But if it is single name and with no nomination, it will be an uphill task for kins to get the flat transferred in their name. So let us find out what role broadly has a nomination to play in a cooperative housing society, that is CHS. In CHS, on the death of the owner, the society is bound to add the name of the nominee in its place, but with a remark saying as nominee. Nominee is a person who, in the absence of legal heir, takes control of the flat and holds on to it as a trustee, as a custodian, till the legal heir is established and then hands it over to them. Nominee is therefore merely a custodian of the heir. Here is a HIR. Hence, till the legal heir is or heirs go to the court and get a succession certificate and a letter of administration, or if there is a will, a probate, the nominee takes care of it. The nominee could also be a heir, but he also has to get the probate in his name if there is a will. Only legal heirs are supposed to have a beneficial ownership. That was the point cleared, clarified in nominee's role in the case of Indira Wahi of West Bengal. So there it was clarified that the nominee does not have a beneficial ownership. So that point was very well clarified. At this juncture, let us also understand that cooperative housing society and land are two items which are state subject. So central cannot make any act on this. Therefore, every state in India has its own cooperative housing society acts and rules. But for inheritance purpose, there is a central act called the Transfer of Property Act 1932, which will apply uniformly in all states. And if it is a jointly owned property and the share of the joint owners are not mentioned, under the Transfer of Property Act, all joint owners shall be treated as equal co-owners. That's not natural. If nothing is mentioned, it's equal treated as equal co-owners. Only in case of taxation, in income tax purpose, they will look at what is the amount of contribution by each of them. So that will be the basis on which they will do the bifurcation. They will determine the ownership. As each state has its own property rules, property is governed by the rules as framed by the state. In Maharashtra, you have Maharashtra Cooperative Society rules, and under Section 30, it clearly states the committee shall transfer the shares or interest of the deceased member to a nominated person and mentioned as nominee only. So they should transfer it in favor of the nominee, and within brackets they should mention as a nominee. If there is no nominee, then the society shall transfer to such person as may appear to the committee to be the heir or legal representative. Whom they consider legal heir or representative, they can transfer. That should be secured, and such persons can be admitted as a member of the society. But for all practical purpose, they will be, mentioning it as a not as a owner, but as a trustee. Trustee. Now, yeah. On the reverse of the share certificate, they will mention the nominee's name and mention as nominee only, because they represent legal heirs as trustees or custodians, because they don't have beneficial ownership. Who has a beneficial ownership? Only the legal heirs. Share certificates are issued by the managing committee and it is governed by the Security Contract and Regulation Act. So we are seeing three acts. One is Security Contract and Regulation Act, which governs the share certificate. Transfer of Property Act, which governs the property, and Coop Housing Society Act, which covers the flat ownership. Okay, and hence this Securities Contract and Regulation Act can only give possession, not ownership. Ownership is governed by the Transfer of Property Act. If nominee has been given, then the nominee name can be given in the share certificate. If nominee cannot, but nominee cannot sell because the property card is in the name of the testator. Property is governed by the Transfer of Property Act, while share certificate is governed by the Securities and Contract Act. Difference between will and nomination. Now, in this chart, let us see what is the difference between nomination and will. While you all would have known there is no alternative to will, as it gives complete ownership, it is only one instrument, but till a legal representative of the testator takes appropriate steps, it gets the will probated or obtains a second instrument, that is succession certificate with a letter of admin, the nominee will take custody of the property. He will protect the property till everything is ready for succession. So you have two instruments, one is will, the other is succession certificate. Process is different for them. Nomination does not give any right on property nor ownership, while will gives ownership and right on property, because nominee acts as a trustee only in the interim. He does not become owner. Only in case of insurance, provident fund, pension, and the nominee and will are on the same footing. To say, in case of insurance, provident fund and pension, the nominee normally gets all the money. The only catch here is the nominee must have insurable interest or beneficiary interest. In case of insurance, if there are more than one nominee, the amount of insurance will be distributed equally. So as you can see, normally a nominee holds the person's assets in trust as he is not the owner. If there is a will, the will supersede, of course, and the nomination will be secondary. It will not work here. And if there is no will, then nominee holds the assets as a custodian for time being, as we stated above, till a legal heir is established to claim it. If there is no nomination, no will, that is neither there is a will nor there is a nomination, the legal heir will have a very complex matter in hand. They have to prove themselves as legal heir in a cumbersome process and execute an indemnity bond. There is one question that has been asked by many people. People keep asking, in case of joint ownership, what happens and where is the nominee? If one of the joint owners expires, let's say A and B are the joint owners, B expires, then A will remain the owner, and if there is a nominee, the nominee will come in place of B and will work as a trustee. So there will be a joint thing like a owner and a trustee. So these are parts we have just covered now. Nominee only holds the property interest. If there is no nomination, no will, then of course it becomes a complex matter. We just completed this. Now let us see what is the next section. Slide. Okay, it is nomination in insurance, provident fund, and mutual fund. We have seen above that only in case of insurance policy, nominee gets full money as insurance is based on the basis of beneficiary agreement. Here, nominee gets a right as long as he is also a heir. In this case, if there is a will, still nominee will get the full amount. If there is more than one nominee, each will get equal share. We just saw that above. In case of life insurance, if there is no nominee, parents, spouse, children can receive the amount on testator's death under the Insurance Act 1938 because they are beneficially entitled as provided under the Insurance Act 1938. When one of the nominees is a non-family member, then the insured needs to prove the insurable interest for the nominee. Just to add here, on mutual fund, also nominee becomes a custodian, but in case of provident fund pension, the beneficiary rule applies and is at par with the insurance. Now, the next slide. Nomination in case of banks. Well, this is an interesting one. Now let us look at the nomination in banks. Up to 5 lakhs can be withdrawn and banks allow it. Anything above 5 lakhs, the bank need to ask for legal heir certificate. With this background, let us look at joint holder. As per RBI guidelines and as given in ICICI terms and conditions, the joint holders can continue to operate, that is, the surviving members can continue to operate the account. They only need to inform the bank so that the bank can remove his name. But they can receive funds, deposit checks in the deceased person's name. Only if both dies and there is a nominee comes into picture and he too can deposit any check and claim balance. Banks allow it, but he cannot operate. Nominee cannot operate. He can only maximum transfer up to 5 lakh to his account, and that too he has to distribute to the legal heir. And anything above that, he has to produce legal heir certificate. The bank can transfer the funds to nominee with nominee's account without insisting on a court order or succession order or letter of administration. Rule varies from bank to bank, though some bank may insist on legal heir certificate. On death, one should immediately, as soon as possible, inform the bank. In bank, first they will see if joint holder is there, else they will look for nominee. If no nominee, then they will apply succession rules. In most cases, the nominee is generally the legal heir, so they transfer. But in the case of non-legal heir, then he is treated as trustee till the legal heir claims. If there is a will, such will supersedes, as this gives ownership benefit, including operation, and it needs to be brought to the attention of the bank. In case of mutual fund, a nominee is a custodian. Okay, so that's one part. Now let us look at the next chart. Nomination in DMAT. In DMAT, a nominee gets the status of ownership on the death of the DMAT holder. This is applicable only in case of DMAT. Where there is no nomination in a DMAT account, then you have to notarize a death certificate, apply for succession certificate and a letter of administration and apply. If there are more than one claimant, while it can be converted into joint account, which is a complex matter while operating, it is best to come together, agree on splitting and have a family agreement done or a partition deed done. Get it registered with the registrar of assurance and file the same while applying for succession certificate. This will help one person managing everything. Alternatively, while applying for succession certificate, all legal heirs can give an individual or joint signed settlement deed authorizing only one person to manage the DMAT related matters. So that is on DMAT. What is this chart? Mutual agreement release date. Okay. I think the mutual agreement needs succession certificate is self-explanatory, and in some states, in case of interstate succession, property can be gifted, or the share in the immovable property can be released by the legal heir to each other, maybe to one person also. This can be done by executing and registering the gift deed or release deed with the registrar of assurance. So you make a mutual agreement. You give a release deed to one person. Everybody gives a release deed to one person. So one person becomes the center point, and he gets a succession certificate and acts. And then he has to give proportionate share. What happens if it doesn't give? It can happen very often. We have seen the case where Vijay Singhania gifted the entire industry, JK Group, to Gautam Singhania, and then Gautam Singhania threw him out of the house straight away once he became owner. So it happens. It's happened very often. So it's better to have a family settlement done and give a court order, and always go for will in this case. That's what I keep saying. Okay, friends. I think today we have covered some important points on uh, nomination and their role in cooperative housing society, banks, insurance, mutual fund, DMAT account, etc. With this, we come to the penultimate series of the inheritance law we are compiling. Cooperative housing society law is a series by itself, quite large, and maybe someday I'll try to bring out something on that. Hope you have had a good idea about nomination, and uh, look forward to you in the next series, the next video. And if you have liked it, please do subscribe and leave a comment. Also, you can circulate to your friends who can benefit from this. Thank you so much.